So the types of methods that I'm going to talk about are things such as sea control and denial, the ones we go through in the manual, blockade, visit and search, and deception. And that looks much better. Thank you very much. So we'll try and find a definition, and this really isn't going to be a surprise that, again, trying to find a universally everyone agrees with it definition is just not available to us. And as I said, with the example of mining, it could be the way in which a means or a weapon is used could be part of this as well. Now, there are limits placed on the rights of belligerents, both in terms of weapons themselves, so the means of warfare, but also there are limits that are placed on some of the methods that are used as well. And so the example that we talk about in the Newport Manual is improper use of protected signs or symbols as being a method that is not available to belligerents. But in terms of other restrictions, we've already looked at those restrictions in the previous presentation, so I don't need to go through them again. Let's have a look, though, at what we've described in the manual as sea control and sea denial. Different names are used, but what are we talking about here? We're talking about the ability to restrict, control, restrict, and deny use of certain areas of the sea to your opponent. I mentioned that one of the ways in which that can be done is through the deployment or through a claim that there has been deployment of naval mines. A more modern way of describing this is, we've already heard mention of it, A2AD, anti-access area denial. That acronym is commonly used to describe the operation itself that is taking place. Another way in which sea control and denial of access to the sea can take place is through the use of maritime operational zones. That's another way in which that can happen. And in naval warfare, there's a number of ways in which that has played out over the years. If that's the case, there are issues with notification. There's of the zone. Does it mean, has it been effectively notified to those who are likely to operate in the area? One of the considerations from the Falklands and Malvinas conflict was that the area of operation was not one that was very commonly used by shipping. So there were some reasonably outrageous claims about what was and wasn't permitted in those areas. And it didn't really have a great deal of impact on the conflict itself. Which brings into question, well, enforcement. If you're trying to control access, if you're trying to deny access to an area, have you got the capacity to enforce that? And tomorrow we will talk about targeting, so I dare not talk about that today. But enforcement of the zone, if that's the way you're seeking to do that, is important as well. And then We've also talked about, both during the conference and yesterday and today, that naval operations take place in the context of which not every state, not every user of the maritime spaces is involved in the conflict. And so other lawful users of maritime spaces are trying to go about their business as well. So there's a question in sea control and sea denial of whether you are doing that in a way that unlawfully impacts on the rights of neutral states. And we look at some of that as well. There's a concept in naval warfare that there is you can either call it an immediate area of naval operations. In the Newport Manual, we call it the immediate vicinity of naval operations. It's the same concept. It's the idea that around your platform, you have legitimate concerns about others who are sailing close by to you because you're trying to limit the risk to your forces. Precisely the issue that the Admiral was concerned about in that previous example I gave you with the Argentine 707, where worried about what's flying around his task force. So setting restrictions, and the way that the British tried to deal with that as the task force was heading south was to have basically a mobile immediate area of operations. So it followed the task force as it went south in the South Atlantic. And so that can certainly be imposed, and if a vessel or aircraft doesn't comply with those requirements that have been put in place by a belligerent in the immediate vicinity of the operations, well, there's a heightened risk to that vessel or aircraft that there might be a consequence of not complying with that notification and being aware of what's taking place in that locality. It doesn't mean that the targeting law that you'll talk about tomorrow, it doesn't mean that that is not applicable. It doesn't mean that you can just shoot down anything or sink anything without worrying about whether it is in fact a lawful military objective or not. None of that occurs, but it does put a risk in place. Sea control, I've talked as part of the introduction to this, of the use of mines to form part of sea control. All those issues that I talked about in the previous presentation in terms of notification to the international community, where you can actually lawfully deploy the mines, because one place you're not supposed to lawfully deploy them, of course, is in neutral waters, neutral territorial sea, or archipelagic waters as well. And then if you are using mines for sea control purposes, an obligation to clear and make good after the conflict has taken place. For those lawyers amongst us here, you will, of course, be aware of the Corfu Channel case from the late 1940s, where this was the very issue of control of that area between Albania and the island of Corfu, whether these obligations of notification, obligations of clearance, whether all of those had been complied with. And the International Court of Justice in that case was very much of the view that they had not been complied with, certainly by Albania, in terms of both notification and then not complied with correctly by United Kingdom in relation to clearance either. Okay. So that's sea control and sea denial and some of the ways in which sea control can be sought to be put in place. And we say it very early on in the Newport Manual, you've got a situation with sea control and sea denial where you've got the naval warfare part of the law that's certainly applicable for the belligerents, but coinciding and coexisting with that are the rights that exist for neutrals and other, or neutrals in particular, and their use of the ocean as well. And so that's some of the tension that the Law of Naval Warfare tries to deal with in armed conflict. The next method that I wanted to talk about is blockade. And blockade is a term that is used inaccurately by even many lawyers, many legal commentators, certainly inaccurately by states, and we try and make it clear what we're talking about here in terms of blockade. First of all, the legality of blockade, and is it in fact lawful at all to have a blockade? Well, those who've got questions about that, I think one place to refer you to is the United Nations Charter, which specifically contemplates blockade, might be authorised by the Security Council. So there's some good authority that as a method of warfare, a method of operation, blockade is specifically contemplated under the UN Charter. But what do we talk about in terms of blockade? We've got a number of different bodies of law that have dealt with blockade. The famous Paris Declaration, which you're now all very familiar with, of course, it had a number of parts to it, but the fourth part, again, a very simple a simple treaty, but the fourth part of it talks about blockade and the need for a blockade, if you are putting one in place, to be effective. And what is that going to mean about whether a blockade is or is not effective? It's ultimately going to be a question of fact as to whether blockade is or is not effective. Hague Conventions of 1907, not much really about blockade in the Hague Conventions. The importance that was attached to the free movement of postal items in 1907 comes through. I don't think the current world would attach that much importance to the movement of postal items, but that was one way in which blockade was talked about there in the Hague Conventions of 1907. But otherwise, not a great deal of comment at all. Going back just a second to notification, the types of things that were mentioned, I think by Rob in his discussion about the use of notice to airmen, airwomen, those types of methods of notification. It might be just simply by a state releasing a no verbal, but notification certainly needs to happen by whichever state is claiming that a blockade is in place. So, Hague Convention, not a great deal to say about that. London Declaration, a couple of years later, again, didn't have a great deal to say about blockade, tried to clarify a little bit about blockade and contraband, but nothing particularly great. And then what has actually happened? What do publications like the Newport Manual, San Remo Manual, what do they have to say about this? You can see both Newport Manual, we do deal with it in quite some detail in Chapter 7, and San Remo Manual deals with it in detail with a number of 10 rules there in that manual as well. So, blockade and understanding the way in which blockade works. Let's look at a couple of examples that try and help with this. Once again, going to the war between Russia and Japan, the blockade that took place of Port Arthur. So, in this case, the way that the blockade was enforced was to actually make the navigation impossible. And with blockade, we're talking about the restriction of entry and exit of all vessels. Okay, you can't come in, you can't come out. So that was what happened with a blockade of Port Arthur, that vessels were sunk there to enforce the blockade. That proved a very effective way to do that, and the Imperial Japanese Navy had a very good victory out of that activity in that case. The changing a few years later to the situation that took place in Libya in 2011. This was an example of the UN Security Council putting measures in place through a number of resolutions there to say what could or could not happen. And an example there on that you may not be able to read very well is a transmission from an aircraft to a ship. Do not leave port. Your regime's violating the resolution. If you attempt to leave, you'll be attacked and destroyed immediately. So again, here's clear notification to a vessel that this blockade, this is in fact a blockade. The arms embargo that was put in place by that resolution and allowed those operations to take place, and that was the way that was put in place. And then the third one to quickly look at is, well, what has been or had been taking place, at least in the case of Yemen. Was there in fact any blockade? There's certainly been naval operations taking place to try and stop vessels coming in and out of ports, but the legal criteria for a blockade in terms of everything that we list in the Newport Manual, I don't think that they were fully in place in that situation. And then the fourth one to quickly have a look about is, well, the Black Sea, in terms of what does it require as well. And so a couple of our colleagues who are here with us today have written a little bit about that and questioned whether there has been a blockade at all in the both in the Black Sea and also in the Sea of Azov. And in both cases, both Pete and Martin came to the conclusion that all the criteria that are needed for a blockade were not in place. There were restrictions on movements of vessels, sure. There were statements made by Russia about what might happen, but in terms of enforcement and effectiveness and meeting some of those basic criteria about stopping all vessels' entry and exit, those issues were not met in those cases. It's certainly not. It's not a place that marine traffic is where it once was. That's for sure. But yeah, the accepted criteria for blockade don't seem to have been applied in the war between Russia and Ukraine. I'm not going to talk about NIAC, so we'll go across to the conclusion here. So as I said, it is a key method. Blockade is a key method for the law of naval warfare, specifically contemplated power for the UN Security Council. Really, IAC is where we're concentrating as well. And in modern times, it's a term that's been talked about, but perhaps not properly used and understood. All right, the next aspect of what I want to talk about is visit and search. And again, you've got to take your frame of reference beyond the Law of the Sea Convention, beyond Article 110, and understand that what we're talking about here is a belligerent right of visit and search that arises during armed conflict, not your right of visit that exists under the Law of the Sea Convention. We deal with it in a couple of places in the Newport Manual, as I've got listed there on the slide. So we set out what is required. And it is different to blockade in the sense that blockade have got some very specific criteria, but here you might just be dealing with one particular ship. And the picture that I've got up here on the slide is one that does come from the Russia-Ukraine conflict. There's been a lot of criticism about aspects of that conflict, in particular the way in which Russia has prosecuted the war. But this quote that comes from a Ukrainian official on one of these social platforms talks about a deliberate attack and forced inspection by Russia of the vessel Sukru Okan, international civilian bulk carrier, which was en route to the Ukrainian port of Izmail, is a clear violation of international law of the sea, an act of piracy, and a crime against civilian vessels of a third state. That's what that said. In terms of accuracy of anything in that quote, he got the name of the vessel right, and I think that's about the only legally accurate piece in it, because the rest of it completely ignores the fact that there's an international armed conflict between Russia and Ukraine, and one of the rights that the belligerents have is the belligerent right of visit and search. That's not piracy. That's not a crime against a civilian vessel. And in fact, what happened in this case was almost absolute textbook visit and search by Russia. They came on board the vessel, they were armed, they secured the vessel, they talked to the master, they established what the vessel was doing, what it had on board. They satisfied themselves that the vessel was able to continue its voyage, that it wasn't breaching any legal parameters that Russia had put in place. They got off the vessel went on its way. That's exactly what visit and search requires to happen. And the fact that they were armed and went on board the vessel and conducted that under the law of naval warfare, which is part of the applicable legal regime because there's an international armed conflict underway between those two states, is absolutely fine. So sometimes when you're reading even comments from government officials, and there were others from, not from Ukraine, but from other states who had their thing to say about this interception by Russia, almost all of those comments were legally incorrect because they neglected to understand the belligerent rights that Russia is able to exercise in this situation. So in terms of understanding visit and search, it's talked about and stipulated in a lot of treaties, and you'll have access to these afterwards anyway. But I'm talking there about Hague treaties from 1907, Washington Naval Treaty, Havana Convention on Maritime Neutrality, London Naval Treaty, London Procès-Verbal, Stockholm Declaration, Neutrality, Geneva Convention 2 talks about it as well, and so on. So that, and there's also a lot of mention in other publications such as the London Declaration, Oxford Manual and San Remo Manual, which all brings out the finally where we get to in the Newport Manual of talking about what can be done for visit and search. And we refer to state practice as evidenced by those treaties, as evidenced by the manuals that were on the previous slide, to make it very clear that visit and search is and remains one of those methods of warfare that is available to belligerents. We make it clear also that there is a difference between visit and search and blockade, that it's not the same. So we make that very clear as well. And we also talk about contraband and the distinction that exists with contraband as well. Contraband, so that you understand about it, San Remo Manual does deal with the concept as well, but it is available to a belligerent to make lists of items that are not to be or that are liable to capture as contraband, and so that's another part of the methodology. An example of that here, so from 1939, there were two different types of contrabands that were put in place here, one being what was called absolute and the second conditional. Foodstuffs were under the conditional contraband, but absolutely things such as arms, ammunitions, explosives, etc., fuel that was going to power anything at all, communications equipment, and then monies. All of those were placed on the contraband list by the United Kingdom in that circumstance as well. And this went back to the Kuwait-Iraq situation in 1990, where as part of the Security Council's immediate action in 1990, there were items that were mentioned immediately about being on Iraqi vessels, that those vessels could be inspected to ensure that their cargoes didn't contain items that were not permitted under that resolution as well. All right, nearly there. So Martin mentioned in his presentation a little bit about some of the peculiarities of naval warfare and what is permitted under naval warfare as opposed to land warfare. And in particular, Martin talked about the use of a flag. But other items, other types of deceptions are permitted. It used to be the case when naval forces weren't conducting over-the-horizon warfare in the way that they tend to do now, that disguising the vessel itself so that it looked like somebody else's vessel. Situations where false funnels were created to take your vessel from a 2-funneled vessel to a 4-funneled vessel, and it now looked like somebody else's. Those types of deceptions have long been part of naval warfare, and in some cases may still have a role to play. But there are other types of deceptions that are not permitted. And key amongst those were things like perfidious acts. So where the confidence of your adversary is being invited by use of a sign or an emblem, feigning surrender, those types of activities where you're then trying to gain the advantage, kill your adversary by using one of those prohibited methods of deception. Other types of deceptions that could take place, and certainly did take place during World War II, were things like false communications. This happened with the Battle of the River Plate, where false communications in terms of how close Allied forces were to Montevideo caused doubt in the German captain's mind as to precisely what he had to cope with when he left port there. And so he decided that rather than send his crew to what he thought was going to be a certain death, he would scuttle his ship and not go out and face what he thought was a formidable force based on false comms. Nothing at all wrong with that as a deception, and that's something that potentially could still be applicable today. Intelligence gathering generally, using your systems to pick up information or to broadcast false information is something that naval warfare contemplates. That can certainly be part of what you are doing as well. The rule that Martin was talking about as flying false colours, the requirement is that before you attack, so before you fire your weapon, you have to strike your own show your own colours. That may be applicable in some circumstances still if you're in very close quarters, but if you're launching a missile from 40 nautical miles, its modern applicability is probably questionable. Whether you say you did it or not may not be of much relevance. We make the point that claiming that a vessel is in distress, that you need assistance, and then opening fire in breach of that, breach of that claim. That supposedly is what happened for an Australian vessel back in World War II. If you want to know further about that, you can ask Rob, because he was involved in the inquiry 40 years later after we eventually found the vessel. But that supposedly is what the German raider did to one of our cruisers and ended up killing and sinking the vessel and killing everyone. Well, we make the point that if that's how your behaviour, if it's because of a distress claim, well, that wouldn't be consistent with the law either. And that, I think, is all we have to say about methods in the Newport Manual. Are there any questions that anyone wants to raise about any method?